Good afternoon, everyone. Thank you so much for joining us, and I do apologize with the delay for starting this webinar. You know, technology is wonderful when it works. This afternoon, I just want to give you a couple reminders. You can use the question box on the right-hand side of your screen to type in any questions you have along the way. I also want to remind you for any webinar you're taking through NYSFDA that you must register everyone who would like credit. If you do not register, yet you attend, you will not receive credit. We need to have that registration in prior to the webinar beginning. And that's for you and anyone else who might be listening in. At this time, I would like to thank and welcome Mike for our webinar today, Compliance 101.
Thanks, Kelly.
Go ahead, Mike.
Thanks, Kelly. Good afternoon, everybody, and thank you for joining us today. Before we get into it, I just want to give you a little bit of background about this session. So today's session is actually a little bit of a new twist on our efforts to provide compliance to you guys. As many of you who've joined us for CE sessions over the years know, we oftentimes will drill down into a specific area of law or practice during a session, and it typically covers that one or maybe two topics. But today, we're going to be approaching this from a new angle. What we have for you are actual questions that we have received from members and the answers that we have provided. In some instances, sometimes to protect the innocent, and in some cases, the not so innocent, we have not used names or any other personal information, so it's pretty generic in terms of that, and it protects all personal information, as I said. The questions that we're going to go through are the ones that we have either most recently received or are most frequently received, and the ones that we have handled over the past year. With one caveat, we did not include any COVID questions because, quite frankly, if we did, that would have filled up the entire hour. You're also going to see that we've tried to divide the session as best as we can by topic, and each answer will include the source of the answer, whether that be the statute, regulation, or another source. And one last thing, in addition, as I've said to anyone who's soldiered through any of my previous law presentations, because this involves law and regulation, I'm going to be reading much of what appears on the slide. While it's a bit mundane and not my preferred method of presenting, it is very important that I provide you with the specific actual answers so I am giving you accurate, reliable information. So I will try to provide a little bit off the cuff stuff if I can, but again, I apologize in advance if it's a little drier than usual because of that. And lastly, since this is a new and different approach, we are very interested in your feedback and to hear if you find this format beneficial, interesting, and practical. So please be sure to give us your feedback after the session is completed. I know we started late, but I promise we will still be over in enough time to give you questions and jump off by 2. So without further ado, let's jump into the session. All right. There we go. So the first area that we're going to go through is advertising and signage. So the first question, one of the ones that we get a lot, is are there specific signage requirements? The answer to that question is yes, there are several signage requirements. You'll see there at the bottom that for state purposes, Health Regulation 77.5 is the applicable regulation, and there's also some specific requirements in addition to those that the folks in New York City have to follow based on the rules of New York City. So first, in terms of signage, a funeral firm is required to display an external, or a lot of times we ask if you have to have an outdoor sign, so that's what that means, obviously, an outdoor sign that clearly identifies its building as a funeral home. The sign needs to display the actual name of the firm as registered with the Department of Health, and it must be conspicuously located at or near the main entrance with lettering that is at least 1.5 inches in height. If your firm changes its registered name, then you actually must make sure that your signage reflects the new name. For folks on the call who are in New York City, In addition to that requirement, funeral home must display a sign providing information as it relates to any person or entity that has at least a 10% ownership interest in it. That sign should be placed inside the funeral home's main entrance and be readily visible with lettering at least 1 inch in height. A sign is required for each firm if there is more than one registration at a funeral home location. Our second question in the same category is, must a funeral firm use the funeral firm name and address in advertising, publications, and phone listings? Answer to that question is yes, you must. When it comes to advertising, publications, and phone listings, only the true funeral firm name and address as registered with the department shall appear in the telephone listing or other publications, as well as in all advertising of the firm through any media whatsoever. So if you're on Facebook or other social media, you must follow the rule as well. However, if you have a firm listing outside of New York State, then this would not apply. This would only apply to firms that are in New York State itself. So you might see a listing in a publication for a out-of-state firm. You'll notice they don't provide the same information. That's because New York State's reach does not go beyond the firms it supervises. Can a non-licensed funeral home employees, I'm having a hard time reading my own words. Can non-licensed funeral home employees have business cards? They cannot. Under the Public Health Law, Section 3443, only licensed funeral directors may use business cards. In addition, the card should clearly state that the person is a New York State licensed funeral director. Our next advertising question is it okay to list the funeral home receptionist on the funeral home's website? You can list the receptionist. You can list non-licensees on your website if it's part of your staff. The thing that you have to distinguish clearly on any listing is who is a licensed funeral director and who is not. And that's just to ensure that there is no customer confusion as it relates to who they're speaking with in your firm. Is a funeral home required to have a business telephone? Yep, under that same regulation, which is 77.5, a funeral firm must have a business telephone that is listed and in working order at its registered address, a number of which shall be indicated as the business telephone number. Other telephone numbers also listed for the firm shall be specifically designated as something like residence telephone number, number to call if no answer, or through some other identification. It's really a question that has come up more frequently because of the obviously use of smartphones and whether or not you have to actually have a business phone at your location, since we know that so much of your job entails you to be out of the office. But according to the reg and to the Bureau, when we confirmed, you must have that business telephone associated with the address of your firm location. All right, so we're going to switch gears from advertising questions over to some funeral home business operation questions. And the first question under this category is, can a funeral home charge back to the family a credit card surcharge in New York State? The answer to that question is yes. You'll see the source there is the United States Supreme Court. So it's interesting. It's the court that creates the source. The law itself says you can't. And that's because they worked out a way to kind of split the baby here. So back in 2019, there were several court challenges, including the one that got to the Supreme Court, that were questioning the ban that New York had on surcharging. They were deeming it was a violation of freedom of speech under the First Amendment. So you could, for example, at gas pumps, go out and you could say, you'd see a lot of times there was a cash discount at a gas station for pumping gas. But if you said there was a credit card surcharge, you weren't allowed to put that out there because the law specifically said that credit card surcharges were impermissible. So that went all the way up, as I said, to the Supreme Court, and the Supreme Court ruled that the state law was a violation of free speech under the First Amendment. So the law has not been officially changed. It's still on the books, but the state now allows merchants to assess an additional charge on consumers who make credit card purchases. When it got remanded, which means the Supreme Court sent it back to the state court for implementing the decision, and that went to our highest court in New York State, which is called the New York Court of Appeals. When it got to the Court of Appeals, they stated in their decision that as long as the total dollars and cents price charged for credit card purchases is posted, they can charge a price differential and call it whatever they like, a surcharge, additional fee, or an extra cost. So as long as you're specifically saying the actual dollars that you have to pay, you can have a line that has this additional charge. In practice, what we found is that most places are calling it a credit card convenience fee. You might have seen it on receipts for things you purchased yourself. So that is something that you now are allowed to pass along to a consumer if they're using a credit card to pay for services. The other thing that's important to keep in mind, however, is that while it is legally permissible, there are still requirements that you have to comply with from the various credit card processing companies, meaning the Visas, the MasterCards, Discovers of the world. They each have their own network rules that you'll have to comply with, and you'll have to make sure that you are doing so. You would want to check with your credit card processor if you're choosing to do this, because they will be able to help you make sure that you are complying with all of the network requirements. In addition, that line, that information about the additional differential that the surcharge or convenience fee that you're charging is going to have to be in writing under the state's interpretation of the Supreme Court ruling. So it has to be prominently displayed on a written receipt or any notices that you might post. So again, it is permissible. There's some hoops to jump through and make sure you check the boxes on how it's done, but it is now a permissible practice in New York State. Next question, does state law provide any tax exemptions for funeral service? The answer is yes. So it's done two different ways under Section 1115 of the tax law. So the goods and merchandise that you are selling to a family at retail are exempt from New York State sales tax. Anything, so that's the general rule. And almost everything you do, or I should say that you resell to the family, is going to be tangible, physical in nature. There are intangible goods and services, but those are things like software, goodwill, name recognition, those kind of things, which obviously you're not incorporating into your itemization statement. So for the most part, anything you're selling to the family is not subject to sales tax. However, if there was something that was intangible, it would not be exempt. And in addition, anything that the funeral home buys at wholesale, meaning you're not intending to or not going to be reselling it to the consumer, is subject to sales tax. So if it's something you're buying that you are reselling, when you resell it, you do not have to charge tax. But anything you are buying yourself is subject to the sales tax. Can a funeral firm offer a price match guarantee in which a firm promises to match the GPL prices of a competitor? So under both the New York State regulation, which I have listed for you at the bottom there, Section 79.4, as well as the United States Code of Federal Regulations, you are not allowed to offer price match guarantees. So there was a letter, a formal guidance letter issued by the Bureau of Funeral Directing back in September of 2019 that cited both of these regulations and stating that the general price list must have prices for all funeral goods and services that are regularly offered, and that those prices should be static until updated or amended, at which time the GPL is provided with a date stamp so the families are clear which prices are applicable on that date. So that is something that you have to do. I know that there have been instances where you're working with a family and you might offer them a discount. Those individual one-on-one conversations are permissible, but advertising or stating that you have a price match guarantee is not permissible across. That's something you can do across the board. Okay, we have a couple of these across during the presentation where it's actually a scenario that was presented that was so specific we felt it was important to share with you along with the question. So this is the first one that we'll go through. So this scenario states, a woman wants to rent out a random funeral home to have a memorial service for a friend. No body would be present. The deceased was cremated a few months ago, and the body was taken care of by another funeral home. The service would not be approved by the family. Does the funeral director have any liability if he rents out the place? So the funeral director, according to the Bureau of Funeral Directing, who we asked this scenario to, replied that you would have the same liability as normal for things like slips and falls. But if the group wants to rent the facilities to hold the service for the decedent he didn't cremate, and there will be no body or cremains, and the next of kin of the deceased didn't authorize it, then based on these specific facts, the funeral director would be free to rent the facilities to whomever he or she wants. So again, as you can see, this is one of those instances where I said I want to make sure I'm reading or providing you the specifics. The answer from the Bureau, that section where it says based on these facts, so this is not a general rule. This is based on the very specific facts and circumstances, but obviously would give you an inkling if you had something similar as to the probable answer that you would get. So in this case, again, you didn't take care of the cremation, but there will be no body or cremains. The next of kin is not authorizing it in this instance, but because of those three facts next to each other there, is something that would be permissible for the funeral director to do. Are funeral homes allowed to store bodies for another unaffiliated funeral home in their storage facilities? Yes. So again, this was a question we raised with the Bureau of Funeral Directing. The answer is if the firm offers it on their GPL and subcontracts it to another firm that leases them the refrigeration space, there's no issue. So again, the key there is that it has to be on the GPL first. Another important note that was brought to our attention by the Bureau itself is that this is a change compared to the previous director of the Bureau. So this is now something that is only in place since Mr. Fuller has taken the reins at the Bureau of Funeral Directing. Another business operations question. Can a funeral home in New York State charge an extra $250 to make a removal after 5 p.m.? Again, very specific question. The health regulations 78.4 provide the answer, and the answer to that is no. Under 78.4E2, it specifically states that the price for transfer includes personnel, equipment, and vehicles. There is no provision for differences in when people happen to die. Additionally, such a charge would be open to abuse by the funeral firm, since often the body can be left in the morgue until the funeral home decides to get to it, handing themselves an additional $250 to pad the bill with. In addition, the price removal must be included in the price of direct cremation and direct burial under those other subdivisions of that section of the regulation, as well as in the price for forwarding remains and receiving remains. If the price for the removal varies, so would the price for these items, which makes the use of the GPL pointless. The only qualifying language on the price for transfer is in 78.4G, where the price may be a flat fee priced by zone or stated as a charge for additional mileage beyond a specified distance. So the only differential is that last paragraph there, and the rationale for why it cannot be done based on time of day is set forth based on the subparagraphs of 78.4 that were referenced in the first two paragraphs of this answer. What right does a funeral director have when they are in possession of remains and the family refuses to move forward? This was a question that we posed to the Bureau. The answer is the funeral director should give the family a deadline at which point you declare the body abandoned and turn it over to the county medical examiner for disposal or disposition. A funeral director can also bill whoever gave him or her permission for the transfer of remains for services rendered to that point. We have had, I think obviously you would expect this question started to come up more frequently during the pandemic, and then as people were trying to make decisions, it was becoming a problem for several funeral homes around the state, and families were kind of dragging their feet, for lack of a better phrase, which really wasn't a good phrase I just used, before they could make a decision, and or because they were in family disputes as to what should take place, and an indefinite period of time of holding the body became problematic. So this is what you can do if they are not moving forward. Again, you give them that firm deadline, and tell them what's going to happen if they don't decide by then, and then you can turn it back over to the medical examiner for disposition. All right, we are now going to switch over to another category, which is one that, along with one other we're going to hit, is a very frequently asked about topic, and that is pre-need. And we've had some changes to the pre-need law recently, and obviously a lot of pre-need issues pop up due to irrevocable accounts, especially during the pandemic. So a lot of these questions we get all the time, but they rose to the top over the past year especially. So first question, who is subject to the annual audit requirements contained in the pre-need law? So as you know, we recently changed the law. So folks were asking if they had to be involved in getting an audit. So the way the law reads, as the changes that were put in place were made, it's the pre-need administrator. So anyone who's a pre-need administrator, which is the entity that holds pre-need funds, it could be a bank, a credit union, or a trust. So pre-plan would fall under the definition of a pre-need administrator. So these entities have to undergo an annual audit that provides more financial information to consumers about their pre-need accounts. It also is something that is made available to the funeral homes, which allows you to take a look at what investments are being done, what the rates are, and it helps you make decisions on where you put your family's pre-need funds. So the pre-need administrator, so pre-plan, did this. The law went into effect at the end of 2019. So it was under the law a requirement for an annual audit, and the annual time frame under the law is January 1 through December 31. So the calendar year 2020 was the first year that was used. Under that law, you had 120 days after the end of the year to have the audit completed and made available. So that was May 1st. So as of May 1st, 2021, all pre-need administrators had to have gone through this very specific audit and made sure that they have complied with the law and make that available to folks who are interested in that. So the related question to this are funeral homes required to have the audit as part of this new law? So the only time the funeral home would have to have the audit is if they actually were running their own pre-need trust, because at that point, then they are deemed a pre-need administrator under the law. But if you're using an outside funeral trust, then the funeral home would not have to have that specific audit performed. Are funeral directors entitled to any portion of the administrative fee allowed under the law? This also was a recent change, which now states that yes, a funeral director is allowed to receive basically up to 1/3 of the fee that's authorized to be charged. So basically, the law says 75 basis points can be charged for administration or administrative services on the trust. 75 basis points is basically equal to 3/4 of 1%. The law allows up to 1/4 of 1% of that fund fee that's collected to be shared back with the funeral directors, and the rationale behind that is to compensate the funeral directors who have spent time working with families to do the pre-arrangement and establish the pre-need contract. The sharing of that fee is at the discretion of the trust or the bank or the credit union, and they can do it if they want to voluntarily. It's also something that funeral directors are not required to accept. If it's offered, the funeral director always has the option of whether or not to receive those funds. That also was a very recent change in law. A question we get a lot is, when should a person establish an irrevocable pre-need account? So this is a combination of Medicaid law and of general business law. So basically, if you are an applicant or recipient for Medicaid or SSI, you have to establish these accounts as irrevocable accounts. And that is to ensure that those funds that you've set aside for your funeral are not counted against your income when determining your eligibility for Medicaid or SSI. That has been the general rule. That was always something you could do for yourself. Now, under the laws for the last decade, it also allows for you to have pre-need funeral arrangements for a family member. If you are the recipient or the applicant for SSI or Medicaid and you want to establish a pre-need account for a family member, that also must now be irrevocable. That also then obviously will not count against the person's income for determining eligibility. So it's part of that spend down process that many go through to order to be deemed eligible to accept or to receive, so Medicaid or SSI. The funds, as you know, may not be withdrawn and refunded. The purchaser, however, is able to select a different funeral home at any time and transfer the funds to such funeral home. The folks who have made these arrangements and established irrevocable accounts also can make changes to their arrangements. However, any change to an irrevocable account must be either of equal or lesser value. You can't increase the expense. One other thing that we have been starting to see as a question much more frequently over the last probably 6 months has been situations where people are asking or trying to actually create more than one pre-need account for themselves. But it's very clear under the New York State Medicaid law that an individual may have only one pre-need account. You cannot have more than one. Again, since it's under the Medicaid law, that specifically applies to the irrevocable accounts. Okay, I just mentioned in that last one that you can set it up for a family member. So the question then, obviously, one of those that comes up with that question is, who is considered a family member when establishing an irrevocable pre-need account? So under the law, under the General Business Law, Section 453, a family member is defined to include a spouse, minor, and adult children, including adoptive and stepchildren in this case, siblings, parents, adoptive parents, and the spouses of those individuals. So it's an exhaustive list as opposed to what we call an inclusive list. As an exhaustive list, that is it. That list right there are the only people who qualify as family members. Anybody who does not have that type of relationship listed there is not eligible to be a family member for which an irrevocable pre-need account can be established. If there are funds remaining in an irrevocable account after all funeral expenses have been paid, who receives the overage? Again, under that same section of law, General Business Law 453, any overage that it remains after you've provided the selected funeral services and merchandise have to be forwarded directly to the DSS office in the county where the beneficiary resided at the time of their death. So again, as I mentioned, you can make changes to things during that are equal or lesser value, but you can't add new things to the pre-selected and pre-arranged for services and merchandise to try to spend more if for whatever reason there is extra money in the account. Any overage must be returned to the DSS office. Did I just do that twice? Oh, I think I just answered this question by answering the other one. So as I just mentioned, no, any irrevocable pre-need agreement, including the ones for your family members, if you have that overage, you must forward that money to the social services office responsible in the county where the person resided. So a little bit of a different question. Can the overage be used to add additional things? Can it additional services or merchandise? The answer is no, it has to be returned. Can a funeral home or a funeral director be designated as the beneficiary of a life insurance policy? No, under state insurance law, I've given you the section there, that law prohibits funeral directors and funeral homes from being designated as the beneficiary. So you cannot be deemed a beneficiary of a life insurance policy, either the individual or the funeral home. So I mentioned that pre-need was one of the big topics that we get questions about. Another one that we get a ton of questions about is final disposition. So we have some questions related to final disposition that we're going to go through next. Do foster parents have the right to control disposition of a foster child who passes away? So the answer to that is no. The foster parent-child relationship is not one that is recognized in 4201, which is our final disposition law that includes the list, the priority list or the hierarchy list. So the only time a foster parent could actually control disposition is if they fell into another category. So they would have to move from foster to parent to having legally adopted the child, which would put them number 4 on the list, or if they were appointed the legal guardians, which would be number 6 on the list. And then in either of those cases, they have to make sure that there's nobody in one of the higher categories or on the list that is above them and available. So that is the only instances where a foster relationship, foster parent-child relationship could be used. Again, it's not the foster parent, foster child relationship. It's if that also led to either a legal adoption or a legal guardianship. Can the funeral director serve as the agent for a friend who has no family? The answer to that question is yes. But under the law, if you are serving as an agent, the funeral director cannot be compensated or receive any financial benefit in doing so. So if you're serving as the agent, you are actually going to be doing the services, you can't receive any money for that. If you're acting as the agent and going to another funeral home, you still can't receive any money for anything that you are doing. As you know, there are witnesses that are needed on the forms. For the agent forms, the funeral director can serve as a witness to the signature on a form, but again, they can't be an agent if they're receiving compensation. Are stepchildren considered children when it comes to the final disposition law? No. So basically, the reason is that there is no legally recognized relationship with a stepchild and a stepparent. So under the law, a stepchild is not a legal heir or a legal descendant of that person. That relationship, the legal heir or descendant, is only created if the child is adopted. And once you're adopted, you're no longer deemed a stepchild, you're an adopted child. I mentioned earlier that there was that one provision for family member and irrevocable accounts where a stepchild could be someone deemed a family member for purposes of an individual who's receiving Medicaid, opening up an account. So that's specific to that. But when it comes to final disposition, stepchildren are not considered children under that hierarchy and priority list. If a child is accused, they have not been charged yet, if they are just accused with the killing of a parent, do they need to sign the cremation authorization? Obviously a very specific question, one that we ran by the Bureau, and the Bureau said no, they do not have to sign the form. So a kind of a related question to this one under this scenario would be, is whether that person would have the right to control disposition. So under that Public Health Law 4201 that we just mentioned in the last slide, unless the person is charged or arrested in connection with that death, they can still serve as a person in control. So in this specific scenario, since the person's accused but specifically not charged, assuming they're also accused but not arrested, that person would still have the ability to control disposition. Knowing that the person in control of disposition is often the person who signs a cremation authorization form, it is a little tricky there in terms of how that would work. But again, that individual under that specific question is not required to sign the cremation authorization form. If a couple is separated, not divorced, is the surviving spouse still the next of kin? Yes. So that is both something that the Bureau reinforced as well as something that is in the statute, in the final disposition law, that if you are separated but not divorced, you remain the legal spouse. So until you are legally divorced or legally separated, not just we're separated, you are still deemed the surviving spouse. Does a person need an attorney or notary public when filling out an agent designation form? The answer to that is no, but the person will obviously need two witnesses, as you know, and one of those, as we just mentioned, can be a funeral director. Can a person named as power of attorney appoint themselves as the agent to control final disposition? According to the Bureau, while they are awaiting a formal legal opinion, their preliminary consensus to this question is the answer is no. The power of attorney may not self-appoint, and in New York, they cannot create or modify testamentary instruments. If the decedent wasn't competent to designate, so this was part of the answer that we received. If the decedent wasn't competent to designate an agent in life, the proper party must be determined by the surrogate. We also were told by the Bureau that once they have a formal legal opinion, they will share it with us. So we will be sure to communicate that to all of you. So I get this question, and we get this question a lot about power of attorney and can the power of attorney serve as the agent in control of disposition. The bottom line and the general rule, I should say, is power of attorneys and healthcare proxies, their authority ends when the person dies. So an individual gives somebody the power of attorney to take care of certain affairs for them while they're living. Obviously, the healthcare proxy is applicable to making health decisions. So neither of these are agents for purposes of final disposition due to their role and authority that they were granted under those documents. So a power of attorney document is not an agent to control final disposition, nor is a healthcare proxy. So a consumer coming in saying they are power of attorney and therefore the person in control of final disposition is not true. If that was the case, the law would said you can use your power of attorney, but the law clearly requires a separate form that relates specifically to giving control to someone to make those decisions. Is the funeral director required to obtain documentation for proof of a domestic partnership? So the short answer to that is, under the law, no, you are not required to do so, but I know that there are a lot of you who feel more comfortable, especially if it's something that might be contested down the line, to have some type of proof. So just by way of what probably will happen in practice, 4201 does provide a definition of a domestic partner, and there's several different ways that can happen. You're either a formal party to a domestic partnership or registered as a domestic partner. If those legal documents exist, then asking for a copy of that is definitely something that would probably make you feel more at ease and show that you took reasonable steps to make sure that you were knowing that the person was a domestic partner. You also have situations where someone is named as a beneficiary under someone's employment benefits or health insurance. If that's available information, that would prove it. And then they have that totality of the circumstances. How are you living together? Do you jointly own property? Do you jointly share households expenses and income? Do you have children in common? How long have you been together? All of those things. So there's a certain point in time where if you try to gather all this information and then you have it, you're kind of trying to judge whether or not it's enough. We don't want you to go there. The reason that you don't have to do anything is because the proof is that person is coming in and saying, I'm the domestic partner, and they're filling the at-need form in saying, I am this person I say I am, and there's nobody else I know above me who would have control. So as long as that form is signed, you are covered. But again, I know that just because of family disputes, sometimes you might look to get that information. So those are the types of things that you could collect or ask for if you chose to. That would help you get to that point of maybe feeling a little more comfortable that the person is who they say they are. Can the designated agent refuse to serve at the time of need? Absolutely, the person can choose not to. They can be unwilling, simply refusing. They might not be readily available, or they just might not be competent to serve. And in any of those three cases, you would then go next on the list should go down the list to the next person on the priority list who would come and take that spot. Another scenario situation, a man dies who's been in a group home. The situation is it's a direct cremation. His mom is still alive, but in a nursing home with Alzheimer's. She has a significant other who is her power of attorney. There's also a living aunt and uncle who would be willing to sign, who should sign the cremation authorization form. And according to the Bureau, and I agree, the aunt or uncle should sign, because a significant other is not a legally recognized person on the list. And we already talked about the fact that a power of attorney doesn't cut it, even if, and this is the power of attorney for the mom. It's not even the power of attorney for the person. So it's a step removed. So the significant other is not recognized. The power of attorney doesn't recognize it. So it's the aunt or uncle who should sign, because in this case, the mom who has Alzheimer's is unable to serve in that capacity as the agent. Another scenario question, an adult child, no spouse, no children, passes away and has been estranged from her parents since she was 12, having moved from another country to the United States. The parents stayed in that other country. Her brother is willing to sign the cremation authorization form. However, her parents are reachable but do not speak English. Who should sign the cremation authorization form? So the parents are obviously higher up on the priority list. They are reachable, so they are not unavailable, as I mentioned, if they are available. So you don't go to the next in line. The only way for this to be done that way, where the brother would sign, is for the parents to waive their rights as those in control and cede that to the brother. So now a death certificate question. We have a couple of those, and we have a scenario here. This came from a funeral home. We have a call for a fetal death that occurred at home. She was only 6 weeks gestation. The mother was treated at ABC Hospital earlier in the day and sent home knowing that she would pass the fetus. When she did pass it, she called the funeral home and would like to cremate the remains. She did not go back to the hospital and wasn't under any doctor's care at home for this. The hospital will not issue a fetal death certificate since it did not occur in the hospital, but will write a letter stating that she was treated for a miscarriage and sent home aware that the fetus would pass naturally. We can't get a permit without a death certificate, and the crematory will not cremate without a permit. The mother still has possession of the fetal remains in a container at home. What is the protocol for a fetal death at home, not under a doctor or hospital's care, in order to cremate the remains? In this scenario, we reached out to the Bureau, and because it was under 13-week gestation, a death certificate would not be issued. So the funeral director needs to contact the State Office of Vital Records to get a permit for cremation. Can an eye doctor sign a death certificate for a person that passes away at home? That eye doctor, unless they are an ophthalmologist, meaning a medical eye doctor, as opposed to an optometrist, cannot sign the death certificate. You have to be a medical doctor in order to sign the death certificate. Does a registrar have a specific amount of time to issue a death certificate? So we reached out to the Bureau of Vital Records. So under the law, a death certificate should be registered within 72 hours after death. Neither the law nor EDRS policy or procedure specify a time frame for a registrar to issue a certificate. So the death certificate has to be registered, but issuing a certificate, which is the same thing as asking for a certified copy, there is nothing in the law or EDRS policy or procedure that speaks to this. So per the Bureau of Vital Records, if a funeral director is unable to get in touch with the registrar and or it takes longer than a week to get the certified copy, the funeral director should email EDRS at this email address, edrs@health.ny.gov, and in the first sentence state, per Chris, I always get his name wrong, per Chris S., you have been unable to get in a hold of the registrar and need assistance in getting a certified copy. In our conversations with him, he said if you do that, it'll make sure that that comes to him and he will get on that and help you get the certified copy. Switching over from death certificates to return of cremains. Is a funeral director responsible for ensuring an individual's intentions per the customer's designation of intentions form is carried out when it comes to distributing or sharing the cremains? The answer is no. A funeral director should make sure that the designation of intentions form includes a named individual to return cremations to. The funeral director is responsible for returning the cremains to that person, but not for ensuring the intentions are then carried out. Can a funeral director charge a refundable fee for storing cremains until picked up by the designated individual? No, you cannot. It is impermissible to charge a storage fee or a fee for disposing of cremains as indicated after 120 days have passed. So you have to hold them for 120 days, but then after 120 days, if no one comes and claims them, you can dispose of them, but you cannot charge a storage fee for holding them for that period of time until somebody does come to pick them up. Your only remedy is to dispose of them under the law. A scenario situation under this topic. Funeral home has had the cremains of a woman since 2013. Her husband has been contacted several times, has not come in to get them. He signed the designation of intentions, but this particular version was a shortened version and did not give the funeral home the right to do with them what they wish after 120 days. At the time, this was yesterday, it wasn't yesterday, the daughter of the decedent called. She would like the remains mailed to her. The funeral home once again reached out to the spouse, who is the stepfather of this daughter, with the number they had on file for him, and it was an answering machine that gave them the name of someone else. And they did leave a message. What can they legally do in this situation? So this was a very interesting one. Obviously not something specific you can find an answer in the law or reg on, so we reached out to the Bureau. According to the Bureau, Now that 120 days have passed, the funeral director could have disposed of them in any of the manners stated. The cremains can be given to the daughter. To protect themselves, the funeral director should ask the daughter to make the request in writing, and the funeral director should write down that they just reached out to the husband again after the daughter reached out and explain what happened when they did. So basically, reiterate that scenario up above and get everything in writing to protect yourself. So despite the fact that the form did not have 120 days on it, the fact that the law specifically says that after 120 days you can take action, you can follow the law, even though that form is not even specifically including that language. What options exist for a funeral director who wishes to dispose of unclaimed remains that date back to before implementation of the designation of intentions form? So both under the health law and then confirming it with the Bureau of Funeral Directing, the cremains may be disposed of in a retrieval manner under 4202. That law allows for disposal by, as you all probably know, placement in a tomb, mausoleum, crypt, niche, in a columbarium, burial in a cemetery, or scattering of the remains at sea or by otherwise disposing of such remains as provided by rule of the department. So that's the, as you all know, Public Health Law 4202 language. In this scenario, however, scattering remains would not be permissible. That is not one of the options. In addition, a record of such disposition shall be made and kept by the person making such disposition. Upon disposing of the remains in the manner prescribed above, the person shall be discharged from any legal obligation or liability in relation to such remains. So again, that is following 4202, and the language on the answer is basically from that section of law. Switching gears to funeral director duties. Can a funeral director pronounce a death? Yes, both under Public Health Law 3440 and the New York State Health Regulation 779. A funeral director can pronounce a death, but they cannot certify a death. The pronouncement is limited to only setting a time of death, so folks like EMTs and police may also pronounce a death. So long as the funeral director follows the law's prescribed tests, there is proof of good faith, which also then provides liability protection. And while, again, a funeral director can pronounce a death, he or she cannot be compelled to do so. So we did have a question once where a hospice said they could not be available, and they were saying that they were going to require the funeral director to be available to do so. That is not permissible. Hospice cannot say that you have to be available. You can do it if you like, but you cannot be compelled to do so. Is a funeral director required to supervise the interment of cremated remains at a cemetery? We asked the Bureau, and the answer is no. Burial of ashes, according to the Bureau, is not final disposition, but that took place at the crematory. And because of that, no cemetery would ever be given a burial permit for this. So the Bureau said the rule of thumb is any place you would need to produce and hand over a burial transit permit, a funeral director is required. For example, cemetery for burial, crematory for body delivery, or common carrier. A couple of resident questions that we've received. Is there a limit on the number of residents you can employ at once? No, under the law, there is no limit. As you probably all know, there is Health Regulation 773 does have a list of requirements, such as you've had at least 40 cases, you have satisfactory facilities, things of that nature. Can a registered residence make a removal without a licensed funeral director present? Yes, that is clearly stated both under the law and the regulations. A couple of GPL questions. A consultant company calls a funeral home and asks if the GPL from their GPL from 2006, which they have a copy of, is the most recent copy of the GPL. Does the funeral home need to provide a copy of the GPL to them? No, not in this situation. Under the reg, it's clear that in this situation, it's not required because the trigger is when a person inquires about arrangements or price and availability of funeral service and merchandise. So if this company just asked about whether this was the most recent, it doesn't trigger the requirement to provide a copy, so you wouldn't have to. So it's very specific to the type of question that's posed. And our last question, how many years do you need to keep continuing education credits records? And the answer is 5 years, according to the Bureau of Funeral Directing. So that concludes all our questions and answers. We want to thank you for your time and attention today. Again, apologize for the late start, but we did end a couple minutes late, but pretty much on time. So if there are any questions, we'd be happy to answer them now. So Kelly, I'll turn it back over to you.
Thanks, Mike. So yeah, we do have some questions. The first one is, can an additional fee be charged for additional manpower used for removal? For example, if the person is morbidly obese.
So I will want to confirm this. I remember this question coming in the past, and the answer, I'm almost positive, is no, that if you have a fee for your removal and transfer, it's going to be stated on the GPL, and that's the cost. Whether it requires you to have more people because of the decedent's size or not is not something you can charge extra for. It's very similar to the rationale behind the answer to the question about time of day. But we can confirm that, and if it's something different, we will get word out.
And we also have a question about the Catholic Diocese prepaid funeral plan. Yes. And how that is legal.
So I believe what the individual is referring to is the Catholic funeral plan. It's a plan, for lack of a better word, that is being offered currently and very recently started to come up in the Capital Region through the Albany Catholic Diocese. For those who are not in the region, basically it is a life insurance policy that is offered to individuals. The problem, so that's a legally permissible policy type, right? So people can purchase life insurance policies. They are having the folks who work at the diocese when they're selling burial plots offer these policies as licensed insurance agents or not. In order to receive a commission, you have to be a licensed agent. So they sell the policies. What they are doing is they are going out and online and compiling GPLs and then using those numbers to create different policy amounts that are available. I believe they have 3 amounts right now. The reason, again, that it's permissible is it's just the selling of the life insurance policy. The issue, however, that is something that we have recently raised as a red flag and a problem is that they are marketing this as going in and prearranging a traditional Catholic funeral. As you all know, that is impermissible. Only a funeral director can make those prearrangements by law. The advertisement makes it appear as though you're going in to do prearrangements. So we have submitted a letter to the State Attorney General, Department of State, and the Bureau / Department of Health, expressing our concerns and asking them to require them to cease and desist from any mentioning or advertising that this is some type of prearranging, because it is simply not that. So we are actively working on that. So there's pieces of it that we feel are not legal, but the underlying policy and selling of that life insurance policy is something that is legal.
Okay, I think I understand what this person's asking, but if a person dies in a New Jersey nursing home after less than a year from entry into that nursing home, does the overage go to New York State or New Jersey?
Can you say it one more time, Kelly? I'm sorry. I just want to make sure I have all the details in my head right.
So I'm guessing this person is referring to an irrevocable prepaid trust.
Yep.
If the person dies in a New Jersey nursing home, so they're originally from New York, but they were in a New Jersey nursing home for less than a year, where does the overage go? New York or New Jersey?
That's an interesting question. I bet you there's somebody on the line who probably has experienced this and knows the answer. So it's interesting because it's a state, you're talking about New York State Medicaid that they were receiving, but the rule would be you would go to the local office in the county where you resided at your death, which would be in New Jersey. I do not know the answer to that question. Under the law, you'd say to the county where the person resided, but I don't know if the state has some type of arrangement with New Jersey or if there would just be something that would then go back to the state of New York because it is it was originally a state funded assistance that was coming. So I think we're going to have to look into that, and we'll put something out in one of the publications about what the answer to that is, because I just don't know the answer. If there's somebody else on the line who does know the answer and would be kind enough to type that into the chat box, we'll be sure to pass it along now. But otherwise, we'll look into it.
Great. Within a religious community, when the clergy does have immediate family, what gives the religious community the right to control disposition?
Honestly, I did not know that the religious community had the right to control disposition. That is the first I am hearing of this. So that is another question that we'll need to run by the Bureau to see what the situation is. If the person who asked that question is on and would be kind enough to email me or Kelly, here at the office, so that we can have any more specific details related to that, we will relay that question over to the Bureau and see if we can get you an answer. Actually, same for the person who asked the New Jersey nursing home question. If you can send that to us with any details although I think we have enough there, but if there's any additional details, please pass them along. Otherwise, we'll just take that information and try to get that answer for you.
Okay. A county medical examiner won't accept abandoned remains. Is there any law that says they must accept these?
You guys are stumping me today. I do not know the answer to that question either, off the top of my head. That was a Bureau answer that said you should give them the deadline and then send it back. So that's another question that I would want. I'm going to look and see if I can see anything in the law, but if not, I'll reach out to the Bureau and see if we can get an answer on that one as well.
Okay. Can a funeral home charge a family on a Saturday or a holiday any kind of fee like the cemeteries do?
The way I have always been told by the Bureau is if it's on the GPL, then you can, and it's clearly disclosed, you can mostly sign it unless the law prohibits it. But if it's not on the GPL, then you can't charge that. I have not heard of a prohibition against doing so, but it would have to be fully disclosed and available and sent to everybody on your GPL.
So with that, what if the charge for an extra person needed for lift assistance is on the GPL? Is that permitted?
That for whatever, I can't remember why, but I remember that was something that you could not do. It would have to, because you would just have a line for the cost for that service and not have it subgrouped by categories such as that. But I can confirm that one also with the department or the Bureau, I'm sorry.
Can a funeral home have an additional charge for a home transfer?
I do not believe so. Again, I'm sorry, these are all questions the type of questions are very, the ones that we would normally start researching and then either reaching out to the Bureau if we can't find it in the law. I don't know off the top of my head if that's permissible, but again, I don't think the location allows for that. I think it's the service type would simply be what you have to list. Again, if there's anybody on the call listening still who knows the answers, please feel free to type it into the chat box and we'll relay those.
I was just thinking the same thing, Mike. Normally when these questions come up, we have time to research it before we answer.
Yeah.
Okay, what about, can a fraternal lodge host a memorial service with the body or cremains present?
I am pretty I feel badly that I'm not 100% sure with these, but I'm pretty sure that they can. If you go back to that question about having a memorial, wasn't next to kin, no body was present, but as long as the funeral director is involved in the supervision, like in terms of the remains. Now, once you've given the remains back to the family, then if you're not, I guess it really depends on some of the specifics. Is it part of the services are asking you to help coordinate, or have you done what you are doing and given the cremains back to, it was cremains, right? It wasn't remains.
Yeah, it was a body present or cremains.
Oh, okay. I know, so I'm not, if it's body present, I believe that, obviously the funeral director would have to be involved. Again, it's probably specific based on where you are in the process on terms of the cremains piece. If you return the cremains to the family and later they want to do something and they arrange for that, then that's different than if part of the services they're asking you to perform is a memorial at this location with you overseeing it. I have had questions where we've been asked about having a body present at a home and the funeral director's responsibility, and it's you're not supervising necessarily, you're getting the body, bringing the body to the location, and then it's on the family and and their home insurance and those other things to take care of supervision. That has been an answer we have been given. So I think it might be specific as to whether or not you are still doing this as part of what you were contracted to do by the family. But I don't know of any strict prohibition against the body or cremains being in a location other than the funeral home, like a lodge, for a viewing. So that I do not believe is just prohibited simply because of the law.
Okay, and we did just get confirmation. You can charge for an extra person for a house transfer, but it must be on the GPL.
Okay. So then it might be the same answer for the extra person, but something tells me like that again was for whatever reason it was not permissible. It might be deemed discriminatory. That might have been one of the reasons why. Again, I just want to double check with the Bureau and be sure about that.
Yeah, and the person said that it would be labeled additional assistance on the GPL, if that's of any help. And also, and I think that would be the same question for, can you charge an additional charge for embalming an overweight person?
Okay. That would be another question we'd need to ask.
All right. Can a person in charge of disposition ask the funeral director to scatter the ashes of their deceased loved one on the funeral home property?
Can they ask them to do that? Is that what the question was?
Yes, that's how it's reading.
I believe so. There's nothing that scattering of ashes, unless it's a location that does not permit it. If they ask and you are comfortable scattering it on your property, I don't believe there's only designated areas for scattering, so that would be permissible. Again, I feel badly because these are, like Kelly, like you just said, like usually we get these and we do some little research. These are all questions that I have not been asked a specific question, so I don't like to give a specific answer unless I know 100% that I'm giving the right one. So I'm trying to quickly file through my brain, which is a scary thought in and of itself, and to get you guys the right answer. But I don't want to. I'm not committing yet because I want to be sure, and then we will send a follow-up communication out with these additional questions and answers for everyone.
All right. Here's one kind of related to COVID, but more talking about irrevocable. So 9 months after the death and burial, the irrevocable account has been satisfied, and now the family decides they want a service at a church, which was originally planned, but the money has already been given back to DSS. So does the family at that point need to come up with the money for the service?
This one I do know the answer to, and the answer to that, unfortunately, is yes. So when we reached out to Medicaid early in the pandemic and said, because of the circumstances and people probably choosing to do something later, can they use those funds later, hold on to it before remitting it? The answer was, once everything is completed and all their services have ended, then you need to remit. So that was that gray area where what we advised was either not to submit the claim, or if you submitted the claim and paid yourself for those services, but the family was considering a memorial, to set up a sub-account separate from your other funeral home accounts that was earning interest, and leave those dollars there for the family. And so if they decided to do something like this later, the money was there. And if they didn't, then at some later date, you could remit to the DSS office. So unfortunately, since the money's already gone there, that cannot be retrieved. However, under FEMA's program, where they have funeral assistance, the individual family member who's paying for this could go out and say that because there is no other funds available at this point, you could get reimbursed most likely from FEMA for the cost of the memorial service that they would then have now.
All right. Are we supposed to be charging tax for our services, such as arrangements, supervision, facilities, etc.?
No, I know I said intangible and tangible, and I actually looked up to make sure intangible didn't include those types of services, but you are providing that service that you are providing as an individual funeral director, those things are not taxable, no.
Okay, and here's a COVID question, unrelated to this compliance, although it is still compliance. Is food and beverage allowed back in the funeral home, such as sharing food and beverage?
Yep. So as of yesterday, once we hit 70% vaccination, all those COVID restrictions are no longer mandatory. They are still something a funeral home can choose to follow, but that means everything that was in the guidelines, including sharing food and beverage, contact tracing, floor markers, signs, hand sanitizer, all of those things are no longer mandatory part of operation. So for all intents and purposes, you can deem yourselves back to pre-COVID operations. The only rule is that an unvaccinated person is responsible for maintaining social distancing and wearing a mask, but that responsibility lies with the unvaccinated person, not with you.
All right. Let me see if there's anything else that we could. Can you offer a discount to any veteran if it's listed on your GPL?
That's a good question. I need to confirm. I want to say yes, that's permissible. I'm pretty sure it is, but we will get confirmation for you on that one as well. But I'm pretty sure that is a permissible activity.
All right, and in response to the DSS and which county gets it, Donna said usually the overage would go to the county paying the bills because often people are placed in nursing homes outside of the county where they are residing.
Right. I think the issue here was the one that we weren't sure about was it's across state lines and it's a state Medicaid program. So that's the only nuance is whether it could go there. The general rule, I agree with you. I just don't know if there's something, a nuance because it's going out of state.
All right. Do you have to ask everyone that comes into the funeral home if they have been vaccinated?
No. You no longer have to ask that question.
All right. One last question. You had mentioned that an irrevocable pre-plan, the family can make changes that are equal to or less. If a family has an irrevocable pre-plan with a $500 limo, for example, can the family cancel the limo and use the $500 for something else, like flowers, food, cash advances?
Yes, so as long as the change is being made and you're not spending more than the 500 on those things, you can use those set aside dollars for different services. So those changes can include removing something and adding a different type of service. You just can't add more money. So if it was $500 for limo, we're not going to do that, but we want to spend $800 on flowers. You can't. You can spend $500 on flowers, but you can't spend more. Or you could spend $200 on flowers. You could spend less, but you can't increase the amount that you're allocating and then fund it later on.
Okay, great. Well, that ends our webinar. All the questions have been answered. Thank you so much, Mike. This was extremely informative. I'll just remind everyone that it does take quite a bit of time to get these CEUs uploaded to the portal and confirmed. So please give us about 7 to 10 business days to get that finished. And I just want to thank you so much for attending. And Mike, thank you for presenting.
Yep, thank you all very much. Have a great rest of your day, and I apologize that we weren't able to give you all the answers to all your questions, but we will work on getting all of those for you as quickly as possible and communicate that out once we have answers. So thanks, as Kelly said, thanks again for joining us. Sorry that we ran a little late.
And as always, if you have any other compliance questions, please feel free to call us here at the office or go ahead and email us, and we'll be able to answer them as quickly as possible. Have a great rest of your day.